Okay, we're live. We're gonna record part 2 of California evidence, and it's gonna be like 24, 25 pages the last half. So it should take about 45 minutes of beginning with hearsay. In California, hearsay law is exempt from coverage of Prop 8. This means that even in a criminal case, the usual rules of evidence apply. Hearsay exclusions versus hearsay exceptions. While federal law excludes certain statements from the definition of hearsay and also recognizes exceptions to the rule making hearsay inadmissible, California law only contains hearsay exceptions. In other words, there are no hearsay exclusions in California. However, with respect to the federal hearsay exclusions, you'll see that California generally categorizes the same statements as hearsay exceptions. So 7.1.1, admissions of party opponent statements by or attributable to opposing party. Under federal and California law, the definition of the statements is the same. A statement by a party or by someone whose statement is attributable to the party is admissible when offered against that party. Certain statements of other people, such as authorized spokesperson or co-conspirator, are admissible against the party as a vicarious statement because of the relationship between them. Under the federal rules, an opposing party statement is excluded from the definition of hearsay. In other words, it is not hearsay under the federal rules. However, in California, these statements are still called admissions. Admissions are considered hearsay in California, but are admissible under a hearsay exception. A, vicarious party admissions, agents and employees. Under federal and California law, a statement of a person authorized by a party to speak on its behalf is admissible against the party. When it comes to the admissibility of other employee agent statements, there is a distinction. Under the federal rules, a statement by a party's agent or party's agent or employee is admissible as an opposing party's statement if the statement, 1, considered any matter within the scope of the agency or employment, and 2, was made during the existence of the agency or employment relationship. In California, there is no equivalent provision under the CEC. However, in civil cases, a statement by a party's employee is considered an admission by the employer, where the negligent conduct of the employee is the basis for the employer's liability under respondeat superior. In other words, the employer is responsible for the employee's words only if they are also responsible in tort law because of that employee's conduct. Skipping the hypos, Part B, other California vicarious admissions. California recognizes the following additional hearsay exceptions. In a wrongful death action, statements by the deceased are admissible against the plaintiff. In a parent's action for their minor child's injury, statements by the child are admissible against the parent. In a civil case where a party's right to title or property is at issue and depends on whether a supposed predecessor in interest holds or previously held the right or title, statements made by the predecessor in interest during the time they were supposedly the holder of the right or title are admissible against the party. And lastly, in an action against a decedent's estate, usually a will's case, a statement made by the decedent is admissible against the estate, provided the statement, 1, concerned the matter within the decedent's personal knowledge, 2, was made after the decedent had recently perceived the matter, and 3, was made while decedent's recollection was clear. 7.1.2, prior statements of testifying witnesses. Recall that under the federal rules, a witness's prior inconsistent statement was made under oath. Prior statements of identification and certain prior consistent statements are admissible as hearsay exclusions. That is, they are not hearsay. California recognizes similar hearsay exceptions. Testifying witnesses' prior statement of identification. Under the federal rules, a statement of identification of a person as someone the plaintiff received earlier is not hearsay. In California, statements of identification are categorized as an exception to the hearsay rule. The California exception imposes the following additional requirements. The identification must have been of a person who participated in a crime or other occurrence. The witness must have made the identification while their memory was fresh, and the witness must confirm in court that they made the identification and that it truly reflected their opinion at the time. Testifying witnesses' prior inconsistent statement. As we discussed in the credibility and impeachment module, prior inconsistent statements are not hearsay when offered only for impeachment purposes because they are not being offered for the truth of the fact asserted in the statement. They are simply being offered to attack the witness's credibility. However, when they are offered to prove the facts asserted in the statement, there is a hearsay problem. Under the federal rules, a witness's prior inconsistent statement is excluded from the definition of hearsay if it was made under oath at the prior proceeding. Otherwise, a witness's prior inconsistent statement is hearsay and inadmissible to prove the fact asserted unless the statement falls within some other exclusion or hearsay exception. California recognizes a hearsay exception for the witness's prior inconsistent statement. This exception extends to all prior inconsistent statements of witnesses, regardless of whether they are made under oath. See credibility and impeachment model for hypos. And C, testifying witnesses' prior consistent statement. Under federal and California law, a prior inconsistent statement that is admissible to rehabilitate a witness is also admissible as substantive evidence of the truth of its contents. See credibility and impeachment module for discussion of when a prior consistent statement can be introduced to rehabilitate a witness. Under the federal rules, a witness's offer prior consistent statement is not hearsay. In California, it is categorized as a hearsay exception. 7.2, hearsay exceptions requiring unavailability. 7.2.1, grounds for unavailability. Federal and California law recognize most of the same grounds for unavailability. 1, death or physical or mental infirmity. 2, privilege. 3, refusal to testify despite a court order. 4, absence or inability of the proponent to procure attendance by process or other reasonable means. So comparing to federal, which is PRISM, that's privilege, refusal. Is I illness? No, S is sickness. I wonder if it's incapacity. No. And M is missing, absent. But what is I? Oh, insufficient memory. So memory's not in here. But they do have the sickness and the privilege and the refusal and the missing part. And the illness. So that's what they don't have, is insufficient memory. Under the federal rules, the declarant also is unavailable if their memory fails on the subject matter of their statement. California doesn't recognize this ground, so a witness will be considered unavailable in this situation only if they suffer total memory loss, because that would be a material mental condition that prevents them from testifying. California courts have also held the fear of testifying can be considered a mental infirmity that prevents the declarant from testifying. Statements against interest. Under the federal rules, a statement by an unavailable declarant is admissible if at the time it was made, it was against the declarant's pecuniary, money, proprietary property, or penal criminal interest. In a criminal case, if the statement would have been subjected the declarant to criminal liability, for example, where the unavailable declarant's statement was a confession to the crime, the proponent must offer corroborating circumstances showing that the declarant statement is trustworthy. That sounds like it's all federal, but California exception is broader in two respects. The California exception is it does not include the corroboration requirement for statements subjecting the declarant to criminal liability. It also applies to statements against a declarant's social interest that would risk making the declarant an object of hatred, ridicule, or social disgrace in the community. Former testimony. Federal exception and California difference. Under federal and California law, testimony given under oath at a trial, hearing, or deposition by a now unavailable declarant is admissible if the party against whom the testimony is now being offered had an opportunity and similar motive to develop the declarant's testimony at the prior proceeding by direct cross or redirect examination. All right, so former testimony. So it was given under oath. We know that by a now unavailable declarant. It is admissible if the party against whom the testimony is now being offered had an opportunity and similar motive to develop the declarant's testimony at the prior proceeding by direct cross or redirect examination. Different standards for identity of parties. The opportunity and similar motive requirement means that generally the party against whom the testimony is now being offered must have been a party of the former action. Where this party was not a party in the former action, such statements may still be admitted under the former testimony exception in civil cases, but federal and California law differ on what is required. Under the federal rules in civil cases, if a party against whom the testimony is being offered was not a party in the former action, the statement is still admissible if the party's predecessor in interest was a party in the former action. Predecessor in interest refers to a person in a privity relationship and the party with the party. Examples would include grantor, grantee, testator, executor, or joint tenants. California recognizes a similar loophole in civil cases, but does not require the party in the former action to be the current party's predecessor in interest. It is sufficient that the party in the prior action had a similar interest to that of the party against whom the former testimony is now being offered. In other words, the former testimony is admissible if the party in the former action had an opportunity to examine the declarant and the interest in conducting the examination that was similar to the interest of the party against whom the declarant's testimony is now being offered. Next page, page 32, additional grounds for admissibility in California. Goes beyond the federal exception and admits former testimony as an exception to the hearsay rule if the declarant is unavailable and the former testimony is being offered against a person who offered it in evidence on their own behalf at the prior proceeding or against that person's successor in interest. The similar motive requirement does not apply in this situation. So this is when a person who's now unavailable but gave testimony before offered it in evidence on their own behalf. So that's just an additional California exception. Related California law deposition testimony in same civil case. The California Rules of Civil Procedure, rather than the CEC, apply when the former testimony is from a deposition in the same civil case. The deposition testimony is admissible for all purposes of the deponent. One is if the deponent, one, is unavailable to testify at trial, or two, lives more than 150 miles from the courthouse. 7.2.4, dying declaration. Under the federal rules in a homicide prosecution or in any civil case, a statement made by a now unavailable declarant is admissible if, one, the declarant believed their death was imminent, they need not have died, and 2, the statement concerning the cause or circumstance of what the declarant believes to be their impending death. However, in California, the exception is different in 2 important ways. The exception applies in all criminal and civil cases, and the declarant must have died as a result of what happened. Page 33, 7.2.5, statement offered against party procuring declarant's unavailability. Under federal and California law, the statement of an unavailable declarant is admissible in any type of case when offered against a party who has engaged or acquiesced in wrongdoing that intentionally caused the declarant to be unavailable to testify. California recognizes its exception and specifically provides that the judge has discretion to exclude the statement. California recognized, I said that. Related California exception statements of kidnapped or murdered declarant in criminal case. In a criminal prosecution for a serious felony, California recognizes a separate exception for statements of a kidnapped or murdered declarant whose unavailability was caused or aided by the defendant for the purpose of preventing the defendant's arrest or prosecution rather than preventing their testimony at trial. However, for the exception to apply, various detailed requirements must be met. For example, the statement must have been made memorialized by law enforcement in a tape recording or in a rating signed by the declarant, and the statement must be corroborated by the evidence that implicates the defendant in the charged crime, and so on. Other California exceptions requiring unavailability. There are 2 more California-specific exceptions that require the declarant to be unavailable: statements describing the infliction of threat of physical injury and statements of past physical or emotional condition or state of mind when at issue in the case. We'll discuss these exceptions in more depth in the section below because they are closely related to other hearsay exceptions that don't require the declarant to be unavailable. So hearsay exceptions not requiring unavailability, section 7.3 on page 34, present sense impression, part 7.3.1. Under the federal rules, a statement that describes or explains the event or condition and is made while or immediately after a declarant perceives the event or condition is admissible as a present sense impression. The California exception is much narrower. It applies only when a statement explains the declarant's own conduct and is made while the declarant was engaged in that conduct. Related California exception statement describing infliction of threat or physical abuse. In California, a statement made by an unavailable declarant that describes, narrates, or explains the infliction or threat of physical injury on the declarant is admissible if the statement was made at or near the time of the infliction or threat, was either 1 in writing, 2 recorded, or 3 made to a law enforcement official or medical personnel, and was made under circumstances that indicate trustworthiness. Because this hearsay exception requires the declarant to be unavailable, be sure to watch out for confrontation issues. Remember, the confrontation clause applies to testimonial hearsay statements, and some statements to the police are testimonial in nature. 7.3.2, excited utterances, spontaneous statements under federal and California law. A statement relating to a startling event made while the declarant was under the stress of the excitement of the event is admissible. The only difference is that federal rules call these statements excited utterances, and California calls them spontaneous statements. Statements of present state of mind or condition. Under federal and California law, a statement of the declarant's then existing present state of mind, including their motive, intent, or plan, or their emotional, sensory, or physical condition, is admissible. However, the statement of memory or belief is not admissible to prove the fact remembered or believed. The only difference in California is that the trial judge has specific discretion to exclude statements that are made under circumstances that indicate a lack of trustworthiness. Next page, 36, statements made for the purpose of medical diagnosis or treatment. It's kind of hard to see. Under the federal rules, a statement that describes a person's medical history, past or present symptoms, or their inception of general cause is admissible as an exception to the hearsay rule if it was made for and was reasonably pertinent to medical diagnosis or treatment. And the California exception is narrower. It applies only where, 1, the declarant is a minor at the time of the proceedings and was under age 12 at the time of their statement, and 2, their statement was made for the purpose of medical diagnosis or treatment and described an act or attempted act of child abuse or neglect. Related California exception, past condition or state of mind when at issue in case. In California, a statement of an unavailable declarant's past physical condition, emotional condition, or state of mind, including their motive, intent, or plan, is admissible to prove that condition if it is an issue in the case. There is no requirement that the statement be made for medical purposes. The trial judge has specific discretion to exclude statements that are made under circumstances that indicate a lack of trustworthiness. Statements that don't qualify under the present state of mind or condition or the statement for medical diagnosis or treatment exception in California might be admissible under this exception, but remember, the declarant must be unavailable. Business records. Under the federal rules, a writing or recording record made as a memorandum of any act, event, condition, opinion, or diagnosis is admissible in evidence as proof of that occurrence if the elements of the exception are met, made in the regular course of business, or made at or near the time of the occurrence, and so on. The California business records exception does not refer to opinions or diagnosis, but courts will admit simple opinions and diagnosis. A, required foundation for business records. Under the federal rule, a business record can be authenticated by a records custodian or other qualified witness confirming that the record meets the elements of the business record exception. This can be accomplished by either 1, live testimony, or 2, written certification. California requires the records custodian or other qualified witness to testify as to the identity of the business record and its creation. A written certification is not sufficient. Section 7.3.6, public records exception, the federal rules. Under the federal rules, the record of a public office is admissible if it is within any of the following 3 categories. 1, the record describes the activities of the office. 2, the record describes matters observed pursuant to a duty imposed by law, but not including police observations in criminal cases. Or 3, the record contains factual findings resulting from an investigation that was authorized by law. In a criminal case, the prosecution cannot offer a record falling within category 3. Additionally, the record must have been made by within the scope of the duty of the public employee, and it must have been made at or near the time of the event. The California public records exception is broader and does not restrict the record to the above categories, nor does it place the same restriction on the prosecution to or bar the admission of police observations. Under the California exception, a record of an act, condition, or event made by a public employee is admissible if making the record was within the scope of the public employee's duties. The record was made at or near the time of the matters described, and the sources of information at the time of preparation indicate trustworthiness. 7.3.7 felony judgments. Under the federal rules, a felony conviction is admissible under both civil and criminal cases to prove any act essential to the judgment. However, when offered by the prosecution for purposes other than impeachment, judgments against persons other than the accused are inadmissible. What was that? That was like so many negatives. A felony conviction is admissible in both civil and criminal cases to prove any fact essential to the judgment. However, when offered by the prosecution for purposes other than impeachment, judgments against persons other than the accused are inadmissible. What? However, when offered by the prosecution for purposes other than impeachment, okay, that makes sense. Judgments against persons other than the accused are inadmissible. So, said positively, the prosecution cannot admit evidence of convictions against anyone other than the accused. If the evidence is used for any reason besides impeachment. So they're either talking about witnesses or victims. So witnesses and or victims that are obviously not the defendant party may be impeached by felony judgments, and it will be admit. But if the felony judgment was brought to the attention of the court for any other reason besides impeachment, it would not be admitted in evidence. And I just can't understand when that would ever occur, because it's not admissible for any reason besides impeachment. California's specific exception, so how would it get admitted? It wouldn't. So why do they make it so complicated? It's not admissible except for impeachment of victims and witnesses. It's only admissible for when it pertains to the defendant, period. So my computer's went ahead and decided to go to sleep. California's specific exception for convictions applies only in civil cases. Prop 8 doesn't change this hearsay law. However, a certified copy of a judgment of conviction is admissible under the California Public Records exception in both civil and criminal cases. Civil judgments. Under the federal rules, prior civil judgments are generally admissible with certain statutory exceptions. For example, a prior judgment may be admitted to prove matters of personal or family history or boundaries of land. Although these are less likely to be tested, you should be aware that California recognizes two exceptions for civil judgments not found in the federal rules. A party may offer a final judgment against themselves when they sue another for indemnification or to enforce a warranty or to recover for breach of warranty. Where a third-party liability or obligation is at issue in a civil case, a final judgment against that third party is admissible. For example, if a defendant in a case had assumed a third party's liabilities, a judgment against that third party would be admissible against the defendant. 7.3.9 Additional California exception statements by child abuse victim in criminal case. We previously discussed how statements of a child describing acts of child abuse or neglect are admissible under California's medical diagnosis or treatment exception. California recognizes a separate exception that admits such statements where not made for medical diagnosis or treatment, but the requirements are a bit more stringent. As with medical exception above, the child must be a minor at the time of trial and must have been under 12 years old when the statement was made. The differences are this exception applies in criminal cases only. The court must find that there are sufficient indicia of reliability, and either the child must testify at trial, or B, if the child is unavailable, there must be evidence to corroborate the child's statement. Watch out for confrontation issues when the child is unavailable and their statement was testimonial in nature. 7.4 Residual catch-all exception. The federal rules recognize a catch-all exception for particularly trustworthy and necessary hearsay statements. California does not recognize a catch-all exception, but judges can create new hearsay exceptions by decisional law. Part 8 on page 41, it looks like we have 10 pages left. Here we're discussing authentication writings and real evidence. Starting with authentication, we will finish out with some procedural related items. Under authentication is ancient documents. A document can be authenticated by evidence that it is sufficiently old, is in condition that creates no suspicion as to authenticity, and was found in a place where such a writing would be kept. Under the federal rules, a document qualifies as ancient if for the last 20 years. In California, the document must be more than 30 years old. Related hearsay exception. The above concerns the standard for authentication, but remember that there is also a hearsay exception for ancient documents, meaning an authenticated ancient document can be used for truth of its contents. For related documents applies to documents prepared before 1998. In California, the timing requirement is the same as for authentication. The hearsay exception applies to documents that are more than 30 years old. And authenticating writings. Authentication is unnecessary for certain writings. For example, certified public records, notarized documents, newspapers. Federal and California law recognize a similar list of self-authenticating documents. However, in California, trade inscriptions and certified business records are not self-authenticating. 8.2, best evidence rule, secondary evidence rule. As you know, as you may recall, when a party seeks to prove the contents of a writing, the best evidence rule requires the party to produce the original, subject to many exceptions in California. The best evidence rule is called the secondary evidence rule. This rule is exempt from Prop 8 in California. This means that even in a criminal case, the secondary evidence rule applies. 8.2.1, admissibility of duplicates and other secondary evidence. Under the federal rules, where the best evidence rule applies, a duplicate, meaning an exact copy made by mechanical means like a photocopy or carbon copy, is usually admissible to the same extent as the original unless it would be unfair to do so, or a genuine question is raised about the authenticity of the original. Secondary evidence of the contents of the writing, such as handwritten or otherwise reconstructed copies, or oral testimony, is not admissible unless satisfactory excuse is given for the non-production of the original. In California, where the secondary evidence rule applies, duplicates of any written secondary evidence of the contents of the original, such as a reconstructed or handwritten copy, are all usually admissible unless, as above, it would be unfair to do so, or a genuine question is raised about the authenticity of the original. Oral testimony about the contents of the writing is not admissible unless a satisfactory excuse is given for the non-production of the original. Part 9, testimonial privileges. In California, most privilege law is exempt from Prop 8. This means that even in a criminal case, the usual rules of privilege apply. Don't forget that California privilege law applies in a civil action brought in a civil federal court under diversity jurisdiction, under the Erie Doctrine. General considerations, confidentiality. In California, a communication made between persons in a privileged relationship is presumed to have been made in confidence. This is true even if the communication was transmitted electronically. The proponent has the burden of proof to establish that the communication was not confidential. Federal courts do not recognize a presumption of confidentiality for all privileges, though it has been held that communications made between spouses for purposes of the confidential marital communications privilege infra are presumed to be privileged. So that's the general considerations. 9.2, attorney-client privilege. Under the federal and California law, the attorney-client privilege applies to confidential communications between an attorney and the client or the representatives of either made during a professional consultation unless the privilege is waived or an exception applies. During the privilege, under federal law, the privilege survives the death of the client. In California, the privilege ends once the estate of the deceased client is distributed and the executor of the estate is discharged. Corporate clients. Under federal law, the privilege applies to communications from corporations, employees, agents, if they were authorized by the corporation to make the communication to the lawyer on behalf of the corporation. In California, the privilege applies to communications from an employee agent if the employee agent is a natural person to speak to the lawyer on behalf of the corporation in the matter, for example, the corporation's in-house counsel or CEO, or 2, the employee agent did something for which the corporation may be held liable and the corporation instructed her to tell its lawyer what happened. As applied, there is no significant difference between the federal and California standards. Note that there is no privilege for a mere witness who happens to be an employee. Exceptions. Under federal and California law, the privilege does not apply where 1. Multiple parties consult an attorney on a matter of common interest and the communications is offered by one of these parties against another in subsequent litigation. The attorney's services are sought to further a crime or fraud. The communication relates to alleged breach of duty between attorney and client. The client puts the legal services at issue in the case. The communication is relevant to an issue between parties claiming through the same deceased client. Additionally, in California, the privilege does not apply where the lawyer reasonably believes that that disclosure of the communication is necessary to prevent a crime that is likely to result in death or substantial bodily harm. Physician, patient, and psychotherapist patient privileges. Federal courts recognize a psychotherapist, social worker, patient privilege, but not a general physician-patient privilege. Remember, however, that NBE questions occasionally assume the existence of a physician-patient privilege under the majority state rule. In California, both privileges exist. The California physician-patient privilege applies to communication with a licensed physician or someone the patient reasonably thinks is a licensed physician. The communications with the physician's staff member, such as a nurse, while the staff member is serving as the physician's agent to gather information to pass to the physician. California psychotherapist patient privilege covers a wide range of mental health workers, including social workers, counselors, school psychologists, and mental health nurses, assistants, and interns. Section 9.3.1 Exceptions. The following exceptions, which are similar to exceptions of the attorney-client privilege, apply under federal law with respect to the psychotherapist patient privilege, and in California with respect to both privileges, the patient puts their condition in issue as a personal injury lawsuit. The professional services were sought to aid in a crime or fraud or to escape capture after a crime or tort. The case alleges a breach or duty between the patient and the psychotherapist physician, as in malpractice lawsuit. And 4th, the communication is relevant to an issue between parties claiming through the same deceased patient. So on to page 46. Getting ready to wrap up the privileges section. Additionally, in California, the following exceptions apply. The psychotherapist patient privilege does not apply if 1, the psychotherapist has reasonable cause to believe that the patient is a danger to themselves or others and that disclosure is necessary to end the danger. 2, the patient is a child under the age of 16 and the psychotherapist reasonably believes that the child has been the victim of a crime and disclosure is the best interest of the child. Or 3, the psychotherapist has been appointed by the court. The physician-patient privilege is not applicable in criminal cases. Neither privilege is applicable, 1, to information that the psychotherapist physician is required to report to public office, for example, gunshot wounds and some communicable diseases, or 2, incompetency proceedings. Now, privileges relating to marriage is the last section, I believe, on page 46 through 47. 1, the spousal testimonial privilege. The testimonial privilege permits a witness spouse to refuse to testify against their spouse. A federal privilege applies to criminal cases only. The California privileges applies in civil and criminal cases and extends to registered domestic partners. Under California law, the spouse partner of the party may not be compelled to even take the witness stand. California marital communications privilege. This is the second type. Under federal and California law, the confidential marital communications privilege applies in the civil and criminal cases. It can be invoked by either spouse and protects confidential communications that were made during the marriage. The California privilege extends to registered domestic partners. 9.5 Other California privileges. California also recognizes the following privileges. Privileges for confidential communications between sexual assault, domestic violence, or human trafficking, counselor, and a victim of such crimes. A privilege for penitential communications between a penitent and a clergy member who routinely receives such communications and whose religion requires them to be kept secret through the penitent and the clergy member hold the privilege. Both those people do. I remember when a proposition was being voted on to abolish this, so I don't know if this material caught up with that or if it was not voted sufficient to be passed. And the privilege for official government information or the identity of an informer, absent a statute forbidding disclosure of such information, is privileged only if the trial judge concludes that the public interest in keeping it confidential outweighs the need for disclosure. So that's your official government information or the identity of an informer. Privilege for trade secrets, privilege for voters' secret ballot, immunity from contempt of court for a news reporter who refuses to disclose her sources. As under federal law, California does not recognize an accountant-client privilege. Now, next page, 48. Procedural considerations. This is the last 2 pages. Preliminary questions. Remember that a judge determines preliminary questions affecting the competency of evidence, meaning whether it is admissible under the rules of evidence. For example, the judge decides whether a witness is qualified to testify, whether a privilege applies, and whether a hearsay statement falls within a hearsay exception. Under the federal rules, when making these preliminary determinations, the judge is not bound by the rules of evidence except privilege. In California, the judge generally is bound by the rules of evidence. For example, a judge cannot use inadmissible hearsay evidence when making the preliminary determination. That is actually really important. So, how does that work out? The judge generally is bound by the rules of evidence. For example, a judge cannot use inadmissible hearsay evidence when making the preliminary determination. 2, a preliminary question affecting the competency of evidence, meaning whether it is admissible under the rules of evidence. So, if you're a judge and you're trying to decide whether or not to bring in prior acts, and you cannot do so while considering some hearsay that a party and a family member are known to have discussed. So when I was in class and we were dealing with California laws in a criminal sense, the mother had been choked by the son in a prior bad act, and in question, the son had basically killed the refrigerator repair woman, same son, and the question by asphyxiation after other exchanges, and to admit, let's say, the prior bad act, I mean, this isn't the one in question, but let's just, so like that evidence was highly prejudicial and would not come in, basically, but the judge had to make that determination without considering like inadmissible hearsay, which may have been the husband hearing the wife call for help or something like that. So say the wife wasn't, or the mother wasn't available. So you kind of have to decide these things without necessarily all of the information. That's how that kind of works out, and it's really complicated. But the judge can't rule to admit something knowing necessarily things that would not be admissible. Because that wouldn't be fair to the criminal. I'm sorry, the defendant. I think the better example is the case where you got a videotape and the court doesn't know what's on the videotape, but it's supposedly like been recorded like this is the Church of Scientology case. So the videotape was illegally recorded, but the content on it that they want to make admissible cannot be admitted without the judge knowing what it's about. So they allowed the judge to watch the video in camera, like to himself, to decide to admit the video. But if you use that case as an example, it would turn what is being said here upside down. So unless that was like reversed on appeal, it doesn't actually match this rule statement that in California, the judge generally is bound to the rules of evidence. For example, a judge cannot use inadmissible hearsay evidence when making preliminary determinations, whether affecting the competency of evidence, meaning whether that evidence is admissible under the rules of evidence. So yes, that can be pretty tricky. It sounds like California wants to be more restrictive than under the federal rules, making those preliminary determinations. The judge is not bound to use the rules of evidence. I actually think that case is actually still good. It was probably a federal law case, like the Ninth Circuit, not a state law case, which is probably why maybe the federal rules were applied. So that actually might be true, the way that works. All right. So last section, judicial notice of facts. Court's discretion. Under federal and California law, a fact is appropriate for judicial notice if 1, it is generally known within the court's jurisdiction, or 2, it can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. As a general rule, judicial notice of a fact is mandatory only if a party requests it. If not requested, the party has discretion to take judicial notice on their own accord. California recognized an exception to this rule. Even if not requested, the court must take judicial notice of matters of generalized knowledge that are universally known. So universally known is a little bit of a difference in terminology. Now, conclusiveness. Under the federal rules, judicially noticed facts are conclusive in civil cases, but not in criminal cases. This means that the court takes judicial notice. In a civil case, the court instructs the jury that it must accept the judicially noticed fact as conclusive. In a criminal case, the court instructs the jury that it may accept the judicially noticed fact as conclusive, but is not required to do so. In California, the judicially noticed fact is conclusive in both criminal and civil cases. This means that in both criminal and civil cases, the court instructs the jury that it must accept the judicially noticed fact as conclusive. So that's it for California evidence and how it's distinguishable from the federal rules of evidence.